Cohens v. Virginia was the United States Supreme Court decision most noted for the court's assertion of its powers to review state Supreme Court decisions in criminal law matters when the defendant claims that their constitutional rights have been violated. Philip and Mendez Cohen were brothers who managed the Norfolk branch of Cohen's Lottery and Exchange Office of Baltimore. The firm had been established in 1821 by another brother, Jacob I. Cohen Jr. The Cohen firm was a leading vendor of lottery tickets in the United States, though its offices in New York, Philadelphia, Charleston, and Norfolk, and nationwide through the mail. Congress passed a bill to establish a national lottery to raise money for the District of Columbia, and which was conducted by the municipal government. Virginia, meanwhile, had created its own state lotteries and passed a law to prohibit the sale of out-of-state lottery tickets.
And now for a dramatic representation.
Hi, how are you?
Good, how are you?
Doing pretty good.
I'm here to buy some lottery tickets.
You came to the right place because I'm the #1 vendor in the United States for lottery tickets. How many would you like?
I would like 2 lottery tickets.
2? That'd be $5. Make sure it's the right amount. And here's your 2 lottery tickets. Nice doing business with you.
One more thing. You're under arrest by the authority of Virginia for the possession of out-of-state lottery tickets.
The issue was significant as lotteries were one of the chief means by which governments raised capital in the early 1800s. It would challenge the free flow of commerce embodied in the U.S. Constitution and could have emboldened other states to challenge the sale of national lottery tickets elsewhere.
What gives you the right to sell these tickets in Virginia?
Well, I thought because they were national tickets, I could sell them in any state, including Virginia.
Even though they're national, you have to sell Virginia-issued tickets in our state.
Where's my client?
Cohen, let's hope you say another word.
The Cohens hired 2 of the country's top lawyers for their appeal, U.S. Senator William Pinckney of Maryland and recently retired U.S. Representative David A. Ogden of New York. Pinckney was an acquaintance of the Cohen family and a strong proponent of the necessary and proper clause in the doctrine of sovereign immunity.
And now a dramatic representation of Cohens versus the Commonwealth of Virginia.
I will now commence case number 265, Cohens versus the Commonwealth of Virginia. The prosecutor may now state their claim.
It is in the state's opinion that Mendez J. Cohen is in clear violation of Virginia law against the solicitation of national lottery tickets in Virginia.
Thank you, prosecution. I shall now let the defense state their claim.
It was thus my client's understanding that Virginia law prohibited the sale of lottery tickets from other states. However, as his tickets were of the national variety, the law should not apply.
Thank you, defense. It is of the court's opinion that Mendez J. Cohen is in clear violation of Virginia law. Therefore, he is found guilty of all charges presented against him. Case closed.
My client would like to appeal the court's decision.
Your appeal will be taken into consideration by the Supreme Court. The date is to be determined.
The Supreme Court will now hear the defense's case against the appeal of the state of Virginia's decision.
The state argues that the Constitution does not give the Supreme Court appellate jurisdiction over criminal judgments by the state court. Also, the Constitution does not give the Supreme Court appellate jurisdiction over cases in which a state is a party. In effect, the decision was final and unreviewable by the federal courts, even though the decision involved the interpretation and application of an act of Congress. Thereby, it is asserted the court has an unreviewable right to interpret and apply or not apply federal law as it sees fit.
The prosecutor may now state their claim.
In defense of my client, Cases arising under federal law are liable to appellate jurisdiction. This is further reinforced by the Supremacy Clause, which states that federal law is superior to state law. If state court decisions involving federal law are unreviewable by the federal courts, then in theory, each state could prevent the federal government from executing state law, meaning each state has the power to veto federal law. And of course, this is not consistent with the language or the intent of the Constitution, especially the explicit grant of judicial power to the federal government.
Thank you, defense. After deliberation, have the judges reached a decision? Thus, the court will now hear Cohen's case in the Supreme Court.
Chief Justice John Marshall and his associated judges all ruled in favor of hearing and reviewing the state's decision. In the end, the Cohens were still convicted of their charges in the Supreme Court, though the larger issue of the case is paramount in U.S. history. It gave the Supreme Court full ability to review state court cases, and even though the Supreme Court ruled in favor of the state's conviction, it demonstrated the power the federal government had over states in the matter.